Reverend,
Yeah, Moro.
do you know where Ken is? Have you spoken to him? Have you been in touch with him?
I may not respond to that.
Anyway, what do you think of this?
I may not respond to that. But
Yes.
Moro, for me, I consider the press conference organized by the Office of the Special Prosecutor yesterday and the pronouncement of the respected former Minister for Finance, Honorable Ken Ofori-Atta, as fugitive of justice, this act as far-fetched, misconceived, lawless, and complete abuse of due process.
Why do you say so?
It is even an abuse of the word fugitive itself. I am always in support of state institutions and organs of state.
Okay.
You know, exercising their mandates, particularly mandates that are geared towards recovering loots, ensuring corruption is prevented, and ensuring that we maximize our resources, our modest resources, in the most efficient way. Now, the records of prosecutions or investigations conducted into specific allegations of corruption or suspicion of corruption by the Office of the Special Prosecutor, and the number of those which eventually even got discharged at the investigation level, and the people involved, the suspects involved, declared as acquitted or cleared by the Office of the Special Prosecutor just at the initial or levels of investigation, must indicate that there is no suspect that should be presumed guilty and unwarranted pronouncement made on them at very initial stages of investigation. Also, the record of the investigation and prosecution of cases as conducted by the Office of the Special Prosecutor, some of which ended up in the court, some of them were acquitted and discharged, should also indicate that even when you have been able to establish prima facie case basis to even, obtain court order for the arrest of a suspect, and even to haul a suspect before the court for the court to determine the matter, even at that stage, it is still premature for you to make certain unwarranted pronouncements.
Yeah.
In any case, per the records or the narration by the Office of the Special Prosecutor, in their narration, on page 3, he narrated that on January 2nd, by the narration of the Office of the Special Prosecutor themselves,
Yes.
on January 2nd, Mr. Ofori-Atta had left the jurisdiction. He himself alluded to that. Now, subsequent
That by January 2nd, Mr. Ofori-Atta had left the jurisdiction.
the jurisdiction. He wasn't in the country.
Yes.
By his narration.
Yes.
I have the
No, at the
document.
time he wrote to him, he was told that he was out of the
let me
jurisdiction.
narrate.
All right.
On page 3, the third paragraph, Mr. Ofori-Atta left the jurisdiction on or around 2nd January 2025.
Right.
The next paragraph reads, this is a report of the
Yes.
Special Prosecutor.
Yes.
On 24th January 2025, the OSP communicated to Mr. Ofori-Atta that the OSP considered him a suspect in respect of the cases, or in respect of 4 of the cases described above. So, nearly like 3 weeks after the former minister had traveled outside the country, you formally wrote to him, notifying him that you have interest in interrogating him, or you are inviting him to assist you on investigation of certain specific cases. Let us be fair. You should not create the impression as though you notified him and subsequent to that he fled the country. He had left the country before you gave him the notice. When the notice was received, as per the report of the Special Prosecutor themselves, when they required him to attend upon the invitation of the Office of the Special Prosecutor on Monday, 10 February, the lawyers of Mr. Ofori-Atta wrote respectfully to respond to them. And I have a copy of the letter here, dated 7th February 2025, by Menka Premo Osebunsu, Bruce Cadlin, and partners, communicating to the Special Prosecutor that the client has instructed them to communicate to them, much as he has no qualms or reservations about turning to them. He's out of jurisdiction. And the basis of he being out of jurisdiction is not to evade law, it's not to evade investigation, but to attend to medical treatment. They further attached a copy of a medical report by a credible medical institution in the United States of America, dated February 7, 2025, indicating that the condition of Honorable Ofori-Atta is such that he needs to stay on for follow-up on his appointments and undergoing further testing and management, including possible surgical intervention in March 2025. This is a doctor's report from a credible hospital in the United States of America. Having communicated same, is there any action exhibited by former Minister for Finance indicating that he's unwilling to cooperate with the Office of the Special Prosecutor in any investigation? In any case, if there are even questions, even if he were in the country, his lawyers have every right, and Mr. Ambassador is a lawyer, his lawyers have every right to even represent him, to cooperate with you, to provide answers. Even when he is present, his lawyers may provide certain responses. Every citizen has the right to resist incrimination. So the police will tell you, you have every right to remain silent, so and so, even before you are presented with any charge whatsoever.
But the OSP says the lawyers are not under investigations.
No.
It is Ken Ofori-Atta who is under investigation.
This is
the
law.
lawyers can guide.
This is law and this is due process.
Okay.
So the person even traveled to seek medical treatment.
Yeah.
And then he has further communicated to you. The letter inviting him was dated January 2024. January 2025. It is not as if he has failed to attend upon your invitation 6 months upon your invitation, or even a year upon your invitation, for you to even be uncomfortable or to have heightened suspicion that the suspect wants to evade your investigation. Just barely days. And the man is sick. Ambassador Piyali gave a very profound local adage about there's also an adage that when chiefs are even swearing before their people or paramount chiefs, they swear to appear before them whenever they are called upon, except in times of sickness. So when sickness comes in and there is a record properly so attached as evidence, you need to show respect and give some time. The doctors in any case had indicated March 2025. We don't know the kind of surgery or the surgical procedure. If they deem him to be recuperating and find him safe at a later period within the year, and they communicate that he can return, so he can return and then continue the investigation. So there is no basis; it's completely unwarranted for him to even cast the insinuation that he's evading investigation. Now, who has the power to pronounce a suspect as fugitive? Is it the Office of the Special Prosecutor? Even the Attorney General does not have the powers to declare a suspect fugitive. It is most derogatory and a willful attempt to defame the respected minister, the former Minister for Finance, Honorable Ken Ofori-Atta. Because when you have followed due process, and for me, he is a lawyer, and I do not cast any insinuation on his conduct in past cases, but I'm talking in respect of this particular case. Others have raised reservations about certain mistakes he made in prosecuting similar cases and how court had evidence of court. Court had the opportunity to point his wrongdoings to him, some errors he committed and all that. In the case of Mr. Bisiu, when he claimed that he had procured the order for his arrest and then he went there, so I have not. All these are there. But it is only when you have established the prima facie case, charged him, and then sent him before the court, he has invaded court, invitation, that you can obtain court order for his arrest. When he refuses, there are legal procedures one can go through. It is only the court that can pronounce a suspect a fugitive. In the case of the former Maslock director, yes, who was outside the country and still outside the country on some alleged medical treatment or so, the case went on from beginning to end and was prosecuted in absentia due processes were followed, and even when sentencing was passed, I'm still sure, I've not had any evidence that she has had the opportunity to even come back to the country to serve the sentence. But the sentence is still valid. But in all this, has any court or any officer or official of the state had opportunity or found it prudent to declare her fugitive of the law? Most derogatory. The fact that if she has been sentenced, she still has her dignity, her respect, and fundamental human rights, which need to be respected. You cannot, you have no right even to make such unwarranted pronouncement on her. Not to talk of a former minister who has just traveled on medical treatment and for just a few days notified you, his lawyers are keeping you updated and showing that they are cooperating with you, and then prematurely organize a press conference. Now, let's come to the other matter. The residence of Honorable Ken Ofori-Atta was raided by military men, and footages of CCTV available indicate that there's one among them alleged to be Mr. Jakpa.
Looks like him. Whether he's
alleged,
the one is
alleged.
Yes.
So I'm saying advisedly, alleged to have been led by Mr. Jakpa, because the footages and images, look like that particular person looks like him. Military men raiding the residence and police officers raiding the residence of the finance minister without any arrest whatsoever warrant, without any warrant to search. They went in, raided with forceful threats they entered and raided, invaded his privacy, invaded his home, and abused his fundamental human rights. The Constitution is here. Article 14 of the Constitution provides the fundamental human rights.
So that's the CCTV footage. That's the CCTV footage on your screens.
Ought to be respected. Even when you consider him a suspect, you haven't even charged him, and he just remains a suspect. Many people have gone through as suspects. You had investigated them and cleared them. So it must indicate to you that it's not every suspect that must be presumed guilty, and subsequently, even a month later, or a month from, it's not even a month from January 2024. It's not even less than a month upon invitation, pronounce him fugitive. That's most misconceived and lawless. Article 14. Every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty except in the following cases and in accordance with procedure permitted by law. So which procedure did they go through? In any case, when the lawyers, being aware that the only state institution investigating their client is, to the best of their knowledge, is the Office of the Special Prosecutor. So if military men in Rambo style have invaded his residence, they saw it fit and respectful to inquire from the Office of the Special Prosecutor to clear their doubts that in case it was sanctioned by them. Yes, you have denied that you didn't sanction that raid. As we speak, no state institution has come to own that they sanctioned that raid.
Or to take responsibility.
What kind of country do we live in? That people's homes can be raided because somebody considers them suspect and can be abused, and then no state, as we speak, is more than 24 hours. There has been no action, no pronouncement from any state agency that they sanctioned it, and people are walking free. Is that how a country that is governed by a constitution and the rule of law, is that how things ought to be done? President Mahama, many had said that has goodwill, and from particularly following the results that came, and that goodwill, for me, for what it's worth, ought to be sustained. But from some of these happenings, the goodwill is being eroded. And so if he is not behind such motivations, he should be firm to be able to deal with certain excesses of certain officers or persons whose inactions or actions will have consequences on his goodwill. It is important.